In this lecture, we take up the question of creditors' rights. Now, the fact is that creditors generally collect the debts that are owed to them. So the credit system that we have in place usually works, and despite talks of rising bankruptcies, the fact is most people pay their debts. Now, creditor is anyone who is owed money by a debtor. And sometimes a debtor cannot or will not pay. The law is going to protect the creditor. The law provides a means to protect the creditor's right to payment. And for business managers like yourself, you need to understand the law and the remedies that it provides to creditors. So today we're going to examine the rights and remedies of creditors. And after this lecture, you should be able to answer the following questions. What is a lien? What are two types of statutory liens? What is a judicial lien? What is a foreclosure of a mortgage? What's the difference between a suretyship and guarantyship? And what protections does the law give to debtors? Now, both the common law and the UCC are going to provide protections for creditors. Remember, creditors are people that are owed money by debtors. Now, the concept of a lien is key to understanding a creditor's rights. Creditor remedies are usually built around the concept of a lien. What is a lien? Well, a lien is a claim against a debtor's property. Liens and other financial claims have become much more prevalent in recent years as a result of the economic downturn. So a lien is a legal claim on an asset that allows the lien holder to take possession of the asset if certain conditions aren't met. Usually, houses will be subject to a lien in favor of the bank that loaned the money for the purchase of the house. Cars are often subject to a lien until the mortgage on a house or till an auto loan is repaid. The lender has a lien on the property. That means the lien has a claim to the asset. And if the debtor falls behind on its payments, the lien allows the lender to foreclose on the house or repossess the loan. Now, a lien is also known as an encumbrance. It encumbers property, whether real property or personal property, by preventing the unencumbered sale of the property. In other words, you have to, if you take property that has a lien on it, you take that property subject to the lien. So a car, a house, a boat, any of those items that are subject to a lien, if you buy those, understand that the lien may take priority over your claim. Now, liens usually arise under statute, such as the Uniform Commercial Code, but can also arise under the common law. Liens can be characterized as either judicial or non-judicial. A judicial lien is a lien that is imposed by a court. Non-judicial liens are liens that arise in any other fashion, such as a voluntary mortgage or giving of a security interest in an automobile. Now, there are different types of statutory and common law liens. A mechanic's lien is something you may have heard of before. A mechanic's lien is not a claim on a car. A mechanic's lien is a claim on real property for payment for any repair or improvement to the house. The purpose of the mechanic's lien is to secure payment for those who furnish labor or materials in connection with the construction of improvements to real property to the extent of the increased value of those improvements to the property. So this often arises in construction, in which a contractor contracts with a subcontractor, who then may contract with several subcontractors, and each of those subcontractors is entitled to a mechanic's lien for the value of their work. And that means that lien is going to take priority over any other encumbrance on the property. An artisan's lien is the claim on personal property. And again, this is another common law lien. This arises out of the work of an artisan. A car mechanic actually would have a right to an artisan's lien instead of a mechanic's lien. So any service that is performed to repair, improve, or enhance the value of personal property is called an artisan's lien. Finally, an innkeeper's lien is lien that's placed on the personal property of a hotel guest. An innkeeper, a hotel, has a lien over the property in your room in the event that you don't pay for the room. So innkeeper's lien is another lien that it derives from the common law. A judicial lien protects the winning party in a lawsuit. That when a party wins a judgment at trial, the losing party may not be able to satisfy the judgment, and therefore the winning party is entitled to a judicial lien. So a judgment creditor, a person who has received a judgment in her favor, is entitled to a judicial lien over the property of the party that has lost the lawsuit. Judicial liens can take different forms. The first is known as a writ of attachment. A writ of attachment is an order, a court order to seize and to take into custody property of the debtor prior to the issuance of a judgment lien. If, for instance, you're in a lawsuit and it appears that the defendant is going to spend all of its money, waste its property, you could ask a court to seize that property pending the end of the lawsuit. That occurs during the pendency of the lawsuit. Now, writ of execution is a court order following the issuance of a judgment lien to seize and sell property of the debtor. So if you are the winning party in a lawsuit and you want to get satisfied, you can then file with the court a motion for writ of execution. If the court grants the writ of execution, that gives to you the power to go to the sheriff and ask for the sheriff to seize property from the debtor and sell it and to give to you the proceeds. Garnishment is another remedy. Garnishment is a legal process that's used by a creditor to seize wages that are held by the debtor's employer. And this garnishment is an example of a statutory lien. If you are faced with a debtor who refuses to pay his debt, you have a right under the law to go to that debtor's employer and have a portion of the debt withheld from each and every paycheck. You can't get the whole paycheck, but you can get a portion of it. An order of garnishment permits a creditor to collect a debt, now keep in mind the law does exempt a substantial part of a debtor's wages or salary from garnishment. This is not a case where you're going to take home 50% of the person's paycheck. The law wants people to keep working, and therefore you are entitled to a percentage, a rather small percentage, but a percentage nonetheless. There are other rights that are available to creditors, and we'll talk about these. Composition, foreclosure, and assignment are rights that the law provides to creditors. Creditors and debtors may enter into a composition agreement. The composition agreement allows parties to settle the debt between themselves. So it allows the parties to enter into an agreement to settle the debt. And so the composition agreement allows the debtor to potentially contract for a lesser amount of the debt. So composition agreements are enforceable, even though they oftentimes involve giving up something that you are already entitled to without payment of consideration. This is a classic example of a lack of consideration. Nevertheless, because of the nature of the composition agreement, we would prefer that composition agreements be enforceable. So in essence, what that means is that a debtor and a creditor can agree to a payment of a lesser amount than the actual amount owed, and that is enforceable despite the lack of compensation that was provided. Duress can invalidate a composition agreement. If you remember back to LSB 3213, you probably can remember a situation involving duress. Duress is a defense to any type of contract, and so it's certainly something that we would look at in terms of settling a debt. Mortgages are the key to real estate financing. A mortgage is a written instrument giving to a creditor an interest in the debtor's real property as security for a debt. Mortgages are issued in conjunction with mortgage loans. That's how we purchase real property. A mortgage is a written instrument that gives to the creditor an interest in the debtor's real property as security for the debt. Mortgages are recorded with the county in the state in which the property is located. Every mortgage must be recorded, and the law provides that those mortgages must be recorded in the county in the state in which the property is located. Why do you think this is? Because if someone is going to purchase property, they will first want to make sure that property is not subject to another lien. Or if it is subject to a lien, what's the amount of that lien, and what is the amount of that interest? And so we provide a recording place in the county in which the property is located. That's why every county will have a county clerk, and that's what county clerks usually do, is to record mortgages and liens against real property located within the county. Now, the foreclosure process is a process that protects the mortgage holder from the debtor's default. A mortgage holder has the right to foreclose on mortgage property if the debtor defaults. So someone has mortgaged their property in order to obtain a loan. A mortgage holder has the right to foreclose on that mortgage property if the debtor defaults. There are many requirements in conjunction with a foreclosure. A foreclosure in general occurs by seizing the property and selling it by means of a judicial sale. So the mortgagee may seize the property, tell the sheriff to seize the property, and sell it at a judicial sale. Those judicial sales are held once a month pretty much everywhere in the country. Now, a problem that can rise is if the sale doesn't satisfy the mortgage, if the property brings in less than what is owed against it, the mortgagee may also seek a deficiency judgment to collect the balance due. So if your house is foreclosed upon and your house is worth less than what is owed, you not only will lose the house, but there's a chance that the bank will attempt to gain a judgment for the difference in the amount between what the house brought and what you paid. The mortgagor, that's the party homeowner, can sometimes redeem the property Virtually every state has a redemption period that if your mortgage property is foreclosed upon, you have a period of time, oftentimes 2 years, in which to get the property back by paying the amount owed. This doesn't happen too often because ordinarily people don't have the money 2 years later in the same way they didn't have the money at the time of the foreclosure. The assignment process is another process by which a third party can control the assets of a debtor. This assignment process permits a third party to come in and take control of the assets. So a debtor may be able to assign all of his assets to a trustee who's going to act for the benefit of creditors. This is how bankruptcy works. A court may also order control of assets to be put in the hands of a receiver. Again, a receiver is a party that is acting in the interest of the creditors and not so much the interest of the owner. Creditors can force a debtor into involuntary bankruptcy if creditors can assert that a debtor is unable to pay his debts. The creditors can force that debtor into bankruptcy, even though the debtor does not want to declare bankruptcy. Creditors can force him into it. Next, we take up the concepts of suretyship and guarantyship. Suretyship and guarantyship involve the use of third parties to obtain credit. Oftentimes, borrowing money requires the good credit of a third party. You may not have good credit, but your parent or your grandparent or a friend, someone close to you, does have the good credit. And we allow the use of that third person's credit through use of either a suretyship or a guarantyship. Anytime someone promises to pay the debt of another, creates either a suretyship or a guarantyship. The difference between the two: suretyship is a promise made by a third person to be primarily liable on a debt. So if you want to open a business and you have a party that is willing to put their good credit to your use, that the bank may insist on that person being a surety, meaning if you don't pay the amount, I can turn directly to the surety for repayment. I don't have to go to you first, and if you can't satisfy the amount, turn to the third party. That's a suretyship. A guarantyship is a promise made by a third person to be secondarily liable. So a secondary liability means that I may have to pay the debt of another, but not until the creditor has done everything in its power to obtain repayment from the original borrower. So a surety states that he will be primarily responsible in case of default. A surety involves an express promise by a third party to a creditor to be primarily responsible for the debtor's obligation to the creditor. And in fact, the creditor can demand payment from the surety as soon as the payment is due. So a surety, when the debt becomes due, the creditor can demand payment from the surety as soon as the payment is due. The creditor does not have to first demand payment from the borrower, the debtor. Sureties are often referred to as a cosigner. You may have heard that term before, to have someone co-sign a note with you. A cosigner obligates themselves to be primarily liable for your debt. In fact, a surety can also act as an insurer of sorts, essentially what a surety doing is providing insurance for the repayment of a debt. Now, guarantor states that he will be secondarily responsible in case of default. So what is a guarantyship? Guarantyship is an express promise by a third party, the guarantor, to a creditor to be secondarily responsible for the debtor's obligation to the creditor. That, again, the guarantor will be liable for the amount of the debt, but only after the first person, the debtor, has been unable to satisfy the debt. Then the creditor can then turn to the guarantor to attempt to obtain the debt. The statute of frauds applies to a guarantee agreement. If you recall from your LSB 3213, a guarantee of a promise to pay the debt of another must be in writing. Now, a guarantee can take several forms. It can be continuing or specific. It can be specific to one particular debt or one particular event, a borrowing event, or it could be over the course of numerous withdrawals or loans. It can be unlimited. You can apply the guarantee can be for the amount of the debt, or it can be limited up to a certain percentage of the debt, or up to a certain dollar amount. It can be absolute, or it can be conditional, meaning only under certain conditions can the guarantor be held liable for the debt. Those are things that you would negotiate in the course of your making the arrangements for the original debt. Now, the law gives defenses to the liability of sureties and guarantors. First of all, any unauthorized modification to the terms of the underlying agreement will have consequences, meaning if there is a modification to the underlying agreement, and that's not authorized by the guarantor or the surety, then the surety or guarantor's liability is only going to be to the amount that they had originally pledged. If the underlying debt is paid, the guarantor or surety is discharged. That means if the debt is paid, the guarantor or surety have no further liability. If the creditor surrenders the debtor's collateral without authorization, the guarantor or the surety may be discharged to the extent of any resulting loss. What happens here, where the creditor, for whatever reason, has given up its rights in the collateral, and then that means the creditor cannot then simply turn to the guarantor, the surety, for the full amount owed if the creditor didn't protect itself from the collateral. So a debtor often provides collateral to a creditor, and if the creditor takes possession of the collateral, then the surety or the guarantor can deduct the value of the collateral from what he or she owes as the surety. Sureties and guarantors are also entitled to assert the same defenses against payment as the debtor, whatever that claim is. It could be a fraud in the inducement or a fraud in the execution, any of those defenses that we talked about in negotiable instruments. Sureties and guarantors may not, however, assert the debtor's incapacity, the debtor's bankruptcy, or the statute of limitations. So if the debtor goes into bankruptcy, that does not free the surety or the guarantor. Similarly, the statute of limitations will differ between the creditor and the surety or guarantor. Now, the law does give sureties and guarantors certain rights. These rights include a right of subrogation. Subrogation is the legal doctrine whereby one person takes over the rights or remedies of another against a third party. Rights of subrogation arise either as a matter of law or by way of contract. Subrogation often arises in insurance contracts, in which if a party pays the debt of another, that party can seek to recover the amount paid if in fact the fault lay with another party. A right of reimbursement, the surety or the guarantor, if they are pay money for the debt of another, they can obtain reimbursement from the debtor. They have a right to assert a claim against the debtor. A right of contribution, meaning if this is the right of a co-surety or co-guarantor to recover from his co-surety or his co-guarantor any cost or expenses expended on behalf of the debtor that was greater than their proportional share. The law provides protections for debtors. The law protects debtors as well as creditors. Consumer protection statutes protect debtors. Bankruptcy laws protect debtors. Certain property of the debtor is exempt from creditors' actions. Depending on what state you are in, for instance, there's going to be a limit to how much of your property the creditor can seize. Certain real property is exempt from a creditor's action. This is often in conjunction with what's called the homestead exemption, meaning that if a piece of real property is your homestead, if it's where you live, then there are limitations on the ability of a creditor to seize that homestead. They're entitled only to a certain amount. Or in some states like Texas, the homestead exemption prevents the seizure of the house other than through purchase money, security interest. State law will protect all or portion of a family home. Certain states do require that there be a family to claim the homestead exemption, meaning if it's a single person, then it may not be subject to the same protections. Certain personal property is exempt from a creditor's action. State law will protect personal property, things like household furniture, clothing, vehicles, as long as that vehicle is being used for work, certain animals, business tools. Those are all protected by state law from creditors. So usually your family pets are off limits to creditors. The tools of your business are off limits to creditors as well. The law protects debtors from unfair debt collection practices. There's a federal law called the Fair Debt Collection Practices Act, which limits the ability of a creditor to harass debtors. This arose about 20 years ago as technology allowed for constant harassment of debtors by creditors, and therefore the Congress passed the Federal Fair Debt Collection Practices Act to limit the ability of a creditor to harass debtors. So in conclusion, what did we learn today? Both the common law and the UCC provide protections for creditors. Composition, foreclosure, and assignment are all creditor tools, and sureties and guarantors have rights and responsibilities. Finally, the law also protects debtors. That's it. Thanks for listening.